You're a member of a jury. A man stands before you accused of killing his wife. Did he do it? Yes. No. Surely there must be some other option. Something other than just guilty or not guilty. In this video, we are looking at Scotland's fascinating third verdict, not proven. We're going to find out what the not proven verdict is, explore one of Scotland's most infamous murder trials, and look at how the verdict is used in a Victorian novel by Wilkie Collins. First, we're going to look at language, particularly what not proven means and where it stands in relation to guilty or not guilty. Guilty or not guilty? These words seem like firm opposites for many in the English-speaking world. In novels and films, a judgment of either guilty or not guilty finally bursts the suspense to bring shock, justice, or devastation. In real courtrooms, a verdict of guilty or not guilty can destroy lives, tear apart families, or finally allow for a sense of closure. And lying somewhere between the two are the celebrity court cases that cause media and public debate over who did or did not do it, who is or is not guilty. But what both real and fictional legal cases share is the profound effect a verdict of guilty or not guilty can have on society and culture. It's enough to think only of the guilty verdict in To Kill a Mockingbird or the not guilty verdict during the Rodney King trial. But if we compare these opposites, guilty or not guilty, to others such as good or evil and black or white, we quickly realise that in terms of language, guilty or not guilty are far from true opposites. That, of course, would be guilty or innocent. And speaking of innocence, in both fiction and reality, we often hear the phrase innocent until proven guilty. In this phrase, innocence truly is at stake, but only, it often seems, up until the reading of the verdict, at which case innocence dilutes into not guilty. But this does make legal sense. After all, the work of a trial is not to prove innocence, but rather to prove guilt with sufficient evidence. When all you're trying to do is prove guilt, any other finding can only be an absence of guilt, which is to say, not guilty. Under the Scottish law, a jury can declare guilty, not guilty, or not proven. A finding of not guilty and not proven both lead to the accused release and inability to be retried for the same offence. So, what exactly is the difference? Well, the Scottish Government website tells us that there is no standard definition of what the not proven verdict actually means. Even more interesting is that due to potential influence and appeals, judges' hands are effectively tied from explaining what, in their opinion, a finding of not proven truly entails. To quote, "It is thought to be good practice to simply inform the jury that there are two verdicts of acquittal and that the accused cannot be tried again for the same offence." So, if the legal ramifications are identical, the difference must stem from the words themselves. If we imagine a spectrum between guilty and innocent, not guilty seems much closer to innocent, whereas not proven seems far closer to guilt. And it's for this reason that the not proven verdict is colloquially understood to mean not guilty, but don't do it again. And this colloquial understanding is exactly what we see in The Law and the Lady. Wilkie Collins The Law and the Lady, a sensation novel from 1875, offers a fascinating entry point into Scotland's unusual third verdict. In the novel, we follow a young woman called Valeria as she investigates a sinister mystery surrounding her new husband. Shortly after marrying Eustace Woodville, Valeria discovers that he has been keeping a secret, that his real name is not Woodville, but rather Macallan. Soon later, Valeria discovers that her husband had not only already been married, but had been tried for the murder of his first wife. Eustace's first wife died from arsenic poisoning, and given that Eustace recently bought arsenic and that many witnesses spoke about their loveless marriage, Eustace was quickly charged with her murder. His defense team argued that Eustace's wife asked him to buy the arsenic for her so that she could control a vermin problem and improve her appearance. Note, at this time, arsenic was believed to have cosmetic properties, namely that it could improve the complexion, which obviously, I hope, is a nonsense, so please do not try to use any arsenic on your skin to improve your appearance. You're already beautiful. But with many character witnesses arguing that Eustace could never have killed his wife, the jury was stuck, and they settled on the not proven verdict. Eustace was, of course, free to go, but was left with a stain on his character. And when he married Valeria, he assumed a false name to avoid her discovering this stain, this not proven verdict. But when Valeria does find out the truth, Eustace abandons her out of shame, even though Valeria doesn't doubt his innocence for a split second. Determined to find the truth, Valeria begins her own investigation and ultimately finds proof of his innocence, which is sadly a letter written by Eustace's first wife explaining that she has taken the arsenic to end her own life. The Law and the Lady is fascinating for many reasons. Valeria is surely one of the first female sleuths and amateur lawyers, and other characters offer very interesting explorations of other topics, most notably disability. But it is specifically on this not proven verdict that I focus here, because the novel is absolutely unambiguous in its disapproval of the verdict, or, in Valeria's words, the vile verdict. But it might be useful to understand the origin and history of the verdict itself. It's often seductive to think that something unusual must also be groundbreaking, that it has marinated for a long time in philosophical or sociological thoughts, ready to emerge and change the world for the better or the worse, depending on your point of view. Not proven is undoubtedly unusual. But it was not introduced to improve or enhance the Scottish law under some grand philosophical argument. Rather, it was, as the scholar Ian Willock describes, a historical accident. By the end of the medieval period, Scottish juries were already using terms that decided on an accused's guilt. But a procedural change in the early to mid-1600s removed this decision of guilt from the juries and handed it over to the judge. The jury was left only to decide whether specific claims had been proven or not proven. In other words, the judge decided on guilt, the juries on specific evidence, like an alibi. For a modern-day example, if you watch the verdict for the biggest recent celebrity spectacle, the Depp Heard civil case, you may remember the excruciating list of proven verdicts about specific cases of libel. But getting back to Scotland, in 1728, something remarkable happened during the murder trial of Charles Lyon, the Earl of Strathmore. Robert Dundas, the lawyer defending the accused, James Carnegie of Finhaven, asked the jury to assert its ancient right of declaring a finding of not guilty rather than only declaring whether certain claims had been proven or not proven. And they did. This marked the introduction of the three-verdict system in Scotland, which over time returned fully to the power of the jury. Hence this idea of it being a historical accident, or as I like to call it, a historical hangover. It stayed because people had gotten used to it, not because it was strictly necessary. But a big problem started to emerge. Once removed from its original use and context, that of deciding whether specific claims had been proven or not, the verdict of not proven started naturally to be applied to the jury's renewed purpose, the guilt of the accused. In other words, not proven went from being an assessment of a specific claim, let's say an alibi, to an assessment of the entire case, to an assessment of the person's guilt or innocence. And certainly, by the 19th century, when The Law and the Lady was published, the not proven verdict was already highly questioned, in part because of some very famous trials during a very deadly century. In 1827, almost 50 years before Collins published The Law and the Lady, a Scottish woman, Mary Smith née Elder, was tried for the murder of her servant, Margaret Warden. Margaret was 25 years old and pregnant, with Mary's son rumoured to have been the baby's father. Some days before Margaret's death, Mary bought some arsenic, which she claimed was to control a rat problem. Honestly, during my research for this, I mean, it makes sense because we have different hygiene standards now, but honestly, so many people claimed they were buying the arsenic to control a rat problem. However, when it became known that Mary had given Margaret a strangely coloured drink and a sugar cube just before her death, Mary was arrested for murder. Writer and historian Sir Walter Scott attended this trial and was outraged that the jury gave Mary a verdict of not proven, despite, according to him, her obvious guilt. He wrote in his diary, "She is clearly guilty, but as one or two witnesses said that the poor wench hinted at an intention to poison herself, the jury gave that bastard verdict not proven." Interestingly for Scott, this case meant that one who is not proved guilty is innocent in the eyes of the law, which, as I will touch upon later, is a current complaint made about victims of sexual abuse in regards to the not proven verdict. I was able to source a newspaper report from the trial and found the final sentence striking. The court met accordingly at 2 o'clock, when the jury returned a verdict finding the libel not proven, and, after a suitable admonition, Mary was dismissed from the bar. This trial excited a great deal of interest. Note, rather than today's customary "you're free to go," which seems, at least culturally, part and parcel of the not guilty verdict, here Mary was given a suitable admonition. In other words, at the very least, the judge and the reporter who thought it suitable felt the need to give Mary a stern warning. And both Scott's diary entries and the fact that the trial excited a great deal of interest reminds us that our fascination with giving armchair verdicts of guilty or not guilty has a very long history. Examples of this fascination across the 20th century would be the 1921 trial of Sacco and Vanzetti, the 1951 trial of the Rosenbergs, the 1982 trial against Lindy Chamberlain in Australia, and, most famously, the 1995 trial against O.J. Simpson. But the Victorians were equally glued to their newspapers, and this fascination reached fever pitch in 1857, 30 years after the trial of Mary Smith, in what has become one of Scotland's most famous and infamous murder trials, one that has been a source of continual speculation throughout the nearly 200 years since it took place. On the 23rd of March 1857, Pierre-Émile Langelier, a 33-year-old factory worker, originally from the Channel Islands, was found at home in severe pain, and, despite being rushed to the hospital, later died that same day. It was determined, as you might suspect, that the cause of death was arsenic poisoning, and a search of his house found many letters from a young woman called Madeleine Smith. Madeleine, a 22-year-old Victorian socialite, broke Victorian conventions by engaging in a long, secret affair with Pierre. The two exchanged many love letters and, for a time, seemed betrothed to one another. However, when Madeleine became engaged to a wealthy businessman with considerably better prospects, she abruptly ended the relationship with Pierre and asked that he return her letters. Pierre, devastated, refused this request and instead threatened to expose her. Completely stuck, Madeleine continued to see Pierre, but soon after, he died. Now, when these letters were read, suspicion quickly fell upon Madeleine. Not only had she recently bought several doses of arsenic in the local area, but witnesses attest that Pierre complained of stomachache following cups of cocoa made by Madeleine. So she had both motive and, apparently, opportunity. But Madeleine claimed otherwise, stating that she'd not seen Pierre for at least 3 weeks before his death. Frustratingly for the prosecution, possible vital evidence was lost when police collected the many letters from Pierre's home. Rather than carefully placing letters back in their original envelopes, the letters were in fact carelessly collected, meaning that the original postmarks couldn't date the letters. Whether or not Madeleine had really met with Pierre became a case of he said, she said. We might say that under the original use of the verdict, that specific fact really was not proven. But what about the arsenic? Well, like the trial in The Law and the Lady, Madeleine claims she bought the poison for, of course, vermin control, like everybody else apparently, but also for cosmetic uses. Again, please never try to use poison to improve your appearance. You're beautiful. But it is true that at that time, arsenic was widely sold in the United Kingdom. And, interestingly, due to the many reports of poisonings, a climate of fear had developed in the UK, leading to a new piece of legislation, the Arsenic Act of 1851, 5 years before Pierre's murder. According to this new law, no person shall sell arsenic to any person who is unknown to the person selling such arsenic, unless the sale be made in the presence of a witness who is known to the person selling the arsenic, and to whom the purchaser is known, and who signs his name, together with the place of abode, to such entries before the delivery of the arsenic to the purchaser. And no person shall sell arsenic to any person other than a person of full age. I have honestly never said the word person so many times in my life. But essentially, this meant not only that Madeleine had to sign for it, but she had to do so in the presence of a witness. Moreover, the chemist who sold Madeleine the arsenic confirmed that the arsenic had been dyed, and that any such dye would show up during an autopsy. But the arsenic was found in a dark, thick liquid in the stomach, who many claimed to be cocoa, and so it was thought that any such dye might not actually be visible. But, just as in the Mary Smith trial, witnesses claimed that Pierre had spoken about killing himself, which became a major point of consideration for the jury. Was the affair itself, and the fact that Madeleine had signed for arsenic, enough circumstantial evidence? Or, on the other hand, was the fact that she'd so blatantly signed it in the presence of a witness too blatant? The question came down to, did Madeleine kill Pierre, or did Pierre kill himself? And after deliberation, the jury came back with the now infamous verdict of not proven. The similarities between the two cases are striking. In each, the accused was female. Each victim died of arsenic poisoning. Both cases had witnesses claiming that the victim was suicidal, and each, of course, ended with the not proven verdict. However, one great difference seems to be in relation to the perceived justness of the verdict. In the first, the judge's admonition, as well as the diary entries from Walter Scott, seem to imply that the not proven verdict was too generously given. However, as the academic Sarah Murphy notes, in Madeleine Smith's case, the verdict was generally considered the most just, the most reasonable of the three options, despite, as mentioned, now nearly 200 years of speculation on the result. The Law and the Lady rejects any idea that the not proven verdict can be seen as a useful alternative. In it, we see how a person's life, reputation, and prospects are forever tainted by the verdict. The Scotch verdict, as it is referred to in the novel, has, as mentioned, destroyed Eustace's prospects and any chance for a happy, or at least peaceful, life. Here I want to focus primarily on the way in which the verdict not only destroys Eustace's external life, but more specifically how it affects his entire personality. In no unambiguous way, the not proven verdict becomes almost the entirety of Eustace's sense of self. Obviously, there is the need for him to assume a pseudonym, but this goes far deeper than that. For instance, one of Eustace's friends tells Valeria, I tried to shake Eustace's distrust of your belief in his innocence, and of my belief in his innocence, by every argument and every appeal that an old friend could address to him. He had but one answer to give me. Reason as I might, and plead as I might, he persisted in referring me to the Scotch verdict. And again, in Eustace's own words, "You believe in my innocence, Valeria. The jury who tried me doubted it, and have left that doubt on record. What reason have you for believing, in the face of the verdict, that I am an innocent man?" The verdict here is capitalized, and I think this shows the destructive power it has had, and continues to have, on Eustace's personality. He is the verdict, or at least he feels like that is the case. Later, when appealing to another of Eustace's old friends, Valeria says, "My husband is resigned to the Scotch verdict. His friends, as far as I know, are resigned to it," which I think again highlights the verdict's power. Everybody seems completely impotent in regards to the verdict, except for Valeria, as she continues in a passion worthy of Nemesis herself. "Well, I don't agree with my husband, or his mother, or his friends. I refuse to submit to the Scotch verdict." And thankfully, at the end, we do get a happy English ending, in which Eustace is cleared after Valeria successfully uncovers the truth of his first wife's tragic ending. I do say happy English ending here, though, because it's worth remembering that this really is a very English Victorian novel, meaning that there is plenty of English moralizing going on, and more than plenty anti-Scottish bias. Let's just take a quick look at how various English people refer to this not proven Scottish verdict. "The only chance I can see of winning you back is to change that underhand Scotch verdict of not proven into an honest English verdict of not guilty. There is a verdict allowed by the Scotch law which is not permitted by the laws of any other civilized country on the face of the earth. The resolution is to set that vile verdict right." Ultimately, though Valeria and Collins mount an admirable attack against it, the Scottish verdict has seen no significant change since Collins published the novel, though it is true that its use has been in steady decline. But it's worth noting that over the last few decades, there have been numerous calls to try to scrap the verdict, with various votes in the Scottish government all ultimately failing. But there is a current reform bill which is still under process and which, if passed, will at the very least change significant aspects of the not proven verdict. This is in part due to a particularly strong campaign against it coming from sexual abuse charities. In 2015, a claimant, Miss M, successfully sued her abuser in a civil court, having lost in a criminal court. After this, Miss M started her own campaign, End Not Proven, with the help of Rape Crisis Scotland, and I have taken some statistics from Rape Crisis Scotland's website. The not proven verdict is used disproportionately in rape cases. In 2019-20, only 43.48% of rape and attempted rape cases resulted in convictions, the lowest rates for any type of crime. Not proven made up 44% of rape and attempted rape acquittals, compared with 20% for all other crimes and offences. And according to Rape Crisis Scotland, there are real worries that the existence of the not proven verdict gives juries in rape trials an easy out and contributes to guilty people walking free. On the other hand, there have been several notable attempts to introduce it into the United States of America. Famously, Senator Arlen Specter voted not proved on the harassment charges against Bill Clinton, and Alan Dershowitz, one of O.J. Simpson's lawyers, wrote that there were several calls to introduce the not proven verdict after the trial, due specifically to the constraint between guilty and not guilty. But more than anything perhaps, what the novel shows us is the lived aftermath of a verdict. We, as either spectators or veritable consumers of real-life and fictional verdicts, often lose interest in people as soon as the verdict is known. This might make sense in a guilty verdict, in which hopefully the guilty person will find a form of retribution, but less so in a not guilty verdict. How many not guilty recipients are forever bound to a crime they didn't commit? How many guilty recipients are in fact not guilty? By beginning with the not proven verdict and then exploring its aftermath, The Law and the Lady inverts the traditional narrative. The end isn't the verdict, rather, the verdict is the impetus for the beginning, and the entire novel hurtles forward because the not proven verdict is utterly uncomfortable. It feels wrong, unfinished, indefinite, and I think that is the real use of the novel today. Perhaps we need to start feeling uncomfortable with our own transient fascinations with high-profile cases. Perhaps we need to think beyond the easy but imprecise notions of guilty or not guilty. Not proven, at least in this fictional form, is an uncomfortable cat among the pigeons. Eustace is not guilty of murdering his wife, but is he entirely innocent either? Eustace readily admits that he was a loveless husband, and Valeria herself is pained when she reads the descriptions of the marriage by his first wife. Now, I don't mean to imply in any way that Eustace pushed his wife to suicide, but the novel doesn't allow us to view him as entirely innocent either. But more than anything, this third verdict highlights the power and malleability of language. It is truly fascinating because of its indefinability. And what each of these cases, fictional and real, show is that not proven can be understood to mean guilt-ish or innocent-ish, depending on the crime and point of view. Do you think your country's judicial system would benefit from a third verdict? How much does the choice between guilty or not guilty influence your own thinking about the law? How much does it seem too limited? How would you feel if, like Eustace in the novel, you received a not proven verdict when you really were not guilty? Or how would you feel if, like many sexual abuse victims in Scotland, you saw your perpetrator receive a not proven verdict with its innocent-ish implications rather than a more straightforward guilty verdict? Thank you so much for watching. I will link all my sources in the description. If you enjoyed the video, please like and subscribe to keep up with my next videos, all about the law and literature. Bye!